We'll start by calling 2018-270 from the Baxter County Criminal Docket, State of Arkansas versus Michelle Wood. Ms. Wood, you're appearing before the court this time, is that correct?
Yes, sir.
For the purpose of changing your plea on a charge against you?
Yes, sir.
Okay. And that change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper. Have you discussed the plea with him?
Yes, sir.
You feel you understand what the agreement is?
Yes.
Mr. Cooper, there was an evaluation done. Have you reviewed that evaluation?
Your Honor, I have, and after
Discussed.
speaking with Ms. Wood, we do not wish to challenge that evaluation.
Okay. And that's after your discussion with her, that's her decision.
Your Honor, we have actually, for the record, Ms. Wood and I have actually spoken at the jail. We went over some things, and based upon my conversation with her, it was our decision not to challenge that evaluation. Michelle, is that an accurate statement to the court?
Yes.
Okay. And so the state is ready to move forward, and I take it you were ready to move forward to trial after reviewing that evaluation.
Yes, Your Honor.
Right.
Your Honor, I would also say that I told Ms. Wood that the Public Defender's Office has funds available, that we can hire our own independent psychologist, which would have been available to challenge this evaluation or, in essence, seek a second opinion. She has chosen not to do that. And Michelle, again, is that an accurate statement?
Yes.
All right. Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes.
On the charges in this case of manslaughter, Class C felony, and reckless driving, on those charges, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to an agreement that the court has in its hands here in the form of it's in writing in the form of a plea statement. Have you read through this plea statement?
Yes.
And in reading through it, have you had the opportunity to discuss any questions you had with Mr. Cooper?
Yes.
And do you feel you understand what's contained in this plea statement?
Yes.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes.
You understand the rights that you give up or surrender when you enter a plea of guilty?
Yes.
When you enter a plea of guilty, you're first of all, you're giving up your right to a jury trial. Do you understand that?
Yes.
And then you also give, with that, you give up the right to have an attorney represent you and assist you throughout that jury trial. You give up the right to confront witnesses that would appear and testify against you at the jury trial. And after that, you give up the right to appeal. Do you understand these rights?
Yes.
And you understand that you, the rights then you're giving up.
Yes.
And understanding what rights they are you still willing to enter this plea of guilty?
Yes.
Are you entering this plea of guilty
Yes.
freely and voluntarily?
Yes.
Has anybody in any form or fashion forced you into this plea?
No.
As you're entering this plea here today, are you admitting to your actions that constitute the basis of the crime?
Yes.
Are you admitting that on or about June 12th of 2018 here in Mountain Home, Arkansas, you were operating a motor vehicle at a high rate of speed, well above the speed limit, and in doing so, as I understand it, weaving in and out of traffic, and it resulted in an accident in which you hit another vehicle, and a person with the driver of the other vehicle was, or there was a pregnant person who's a passenger in a vehicle whose child died as a result of this accident?
Yes.
Based on those statements, the court's going to find the defendant has freely and voluntarily entered a plea of guilty, done so after consulting an attorney, and has admitted to the factual circumstances of her actions. And on that basis, the court will accept her plea of guilty, and at this time formally adjudge her guilty of manslaughter, Class C felony, and reckless driving, and unclassified misdemeanor. On those charges, the court is imposing a sentence of 10 years in the Arkansas Department of Corrections on the manslaughter and reckless driving, imposing 10 days in the Baxter County Detention Center. Those sentences will run concurrent with each other. The court is also imposing court costs of $200, a fine of $2,000, a statutory DNA fee of $250, bullion administration fee of $20, and public defender's fees of $200. All of those amounts will be due and payable as a term and condition of the defendant's release from the Department of Corrections once she's completed her sentence. Payments will be made at a minimum rate of $100 per month, beginning within 60 days of her release from incarceration. That'll be the order of the court. The court at this time will remand the defendant in the custody of the Sheriff's Office to await transportation to the Department of Corrections.
Your Honor, the sentencing order, as I understand it, will reflect that she is being given day-for-day credit for all the time that she has served in jail, including any time that would normally be excluded because of the evaluation.
That's in accordance with the law in this case. All right, you may be excused. Frank Elmer McElway.
Yes, sir. Your Honor, I need some help. I mean, I need some help big time.
Mr. McElway, I'm not here to give you some help today. I'm here to do a specific thing
I'm an
because your
innocent
case
man.
hasn't formally been set up. I'm not here to do anything but to administer an 8.1 hearing. I'll hear you out when we get the job I'm here to do. I've got a whole bunch of people waiting to get before me today. I'm not going to take a lot of time with this. You are one of those people who's been picked up by law enforcement on probable cause. A probable cause affidavit has been filed against you, and it's been reviewed by a judge, and bond has been set in this case by the judge reviewing your probable cause affidavit. The charges that are
There's a
contained.
mistake. You make my charges. Sir, I'm not even, I've only lived in Mountain Home for a year, and this man come to my house and wanted me to help him with some work, and I asked him what type, and he said logging. And all he wanted was some help load some cedar wood. My wife encouraged me to go with him, that we needed the money. Me and my wife are disabled people. And I went to work with this man, and I'm on his property, and he told me to get in his pickup truck and warm up in his truck. And I was warming up in his truck, and then the police come up there, served a warrant on him, and I wasn't in trouble. And it seemed like they just all of a sudden just got me in here for no reason. I'm a mental health patient. I go to Ozark Guidance. I need my medication. I need somebody to get my medication for me. I'm not supposed to be in here. I know it sounds funny, but I need to be set free today. I demand y'all to release me, sir, because I have not got any drugs on me. I don't do that stuff, and I don't believe it's right for me to suffer in here. I'm a mental health patient. I got post-traumatic stress disorder. I got anxiety disorder, sleep disorder, and they can verify that at Ozark Guidance. I've been going there for 14 years.
Mr. McElway, I've
worried to
listened
death,
to
sir.
you.
I'm pained
I've
to
heard
this.
your appeal. Okay? Now be
Okay,
quiet
good,
and
Your
let's
Honor, I'm
get.
not guilty.
I'm conducting an 8.1 hearing, and I'm going to complete conducting it. That's all I'm doing today. I'm not the judge on your case at this point. So what I'm advising of you, the reason you were arrested, and you seem to know it, that
Why
you were,
am I arrested?
You were
Why?
arrested because you were with somebody who had some drugs on them.
Yeah, but I didn't. I didn't have drugs on me or nothing like this.
I
I don't sell
understand.
drugs and I don't carry guns and stuff. I don't do it. And I got charged with it. I ain't supposed to be in here, sir. Hey, please let me go home. My wife's disabled and everything.
I've heard you ask that, sir, and I am considering it. But just
Please,
let,
Your Honor, I ain't done it like that.
if you don't shut up, then all you're gonna do is cause yourself to sit there just like you are right now. You're not helping yourself beyond having told me what your situation is. So be quiet and let's finish the Rule 8.1 hearing. The Rule 8.1 hearing is for the purpose of making sure you understand why you're there. You're there because you were with people who got arrested for probable cause involved in having possession of drugs. And the situation is because you were with them, you're considered a co-defendant with them on their charges.
I was a
Now-
laborer.
Sir?
I was a laborer.
Sir, calm down. Just calm down. Get control of yourself.
I don't have my medication. I can't help it. I got post-traumatic stress and everything else. I can't help it. But, okay.
Okay.
I feel like what I'm gonna do in here, but I need to do this stuff these men did.
Sir?
Somebody's gotta believe this, cause I know I ain't done nothing like this. I don't carry guns and sell drugs.
Okay.
Need to go home.
So, the reason you're being held is there's probable cause been found by a judge that you were in possession of drug paraphernalia and drugs, and the bond that judge set is $25,000. So, the reason you're being held is there's probable cause been found by a judge that you were in possession of drug paraphernalia and drugs, and the bond that judge set is $25,000. It's not.
I don't have drugs on me. They patted me down. I don't have drugs.
Your Honor,
What's up here?
I'm finding it difficult to believe why this individual would have substantial additional bond if he's a co-defendant with the other two. And is the state willing to make a recommendation, or?
absolutely, Your Honor. Again, this supports where the state does not set bond. The state has no objection on this bond being reduced to $2,000, Your Honor. We would ask that he be tested by probation and parole. That will let us know how to address the rest of this case, Your Honor.
Can y'all please
Does
give
the
me?
sheriff's office have chemical test kits there?
Your Honor, I can get our folks to do that with the court's direction, Your Honor.
All right. Well, let's get that done. The court's gonna reduce the bond on the state's recommendation, to $2,000, cash or professional.
Sir, I don't have $1 right now.
All right.
Please, y'all just let me go home. OR me, please. I mean, I'm being home all the time anyway. Me and my wife, please, sir, I don't have money to go to bond out right now. I don't get a check till the first of the month, and that's all I got. These are bad men I was with, and I didn't know it, sir. That old man don't look like a bad man. I don't know him. He looks like
Well-
a good old man to me, and my wife even encouraged me, go with him, huh?
Can you please be quiet and let me finish? Okay? Now, because the individual who you were with spoke up earlier, I'm going to consider you for an OR release, okay?
Hey, God.
Now, listen to me. That doesn't mean you're out from under these charges.
I'll go to court. I will go to court. I will. I want these people to get what they deserve. Because I think he should be up here begging you for you to let me go, not me have to beg like I am. He wanted me to help him work.
You need to be quiet and let me finish. You're just prolonging how long this takes. And I'm getting mad because, as I explained to you, I have a whole bunch of people waiting to have their cases brought before me today. I don't have a lot of time to take with your case. All right? I've heard what your plea is. Let me finish.
Yes, sir, I apologize.
Okay. Now, the reason you're being held is because of the drugs that were found and the people you were with. The charges against you have been put in a probable cause affidavit, and that's why you're being held. The bond that was originally set in your case by the judge was $25,000. The state has been willing to reduce that to $2,000. What I'm going to do is I'm going to OR release you if you satisfactorily pass a drug test. There, the probation officer will come over and drug test you. If you do not have drugs in your system, then you'll be released into the custody. You'll be OR released, and you're to remain at your residence, and assuming that if the prosecution doesn't actually file these charges, then you'll just be released. If they file the charges, if the charges are filed, your next day in court will be the 28th of February. And you need to be in the courtroom here in Mountain Home on the 28th on that. That's the condition of your bond, is that you submit to drug testing, and that you and you have to successfully have a negative test, and then you should plan to appear on February 28th in front of Judge Putman, who will be here in a week. If the state goes ahead and files charges, at that time you'll be subject to arraignment on the charges, and Judge Putman or the judge assigned to the case will determine what the bond is from that point on. But I'm going to release you today. You may be excused at this time.
Thank you.
(2014-96) State of Arkansas versus Danielle Astry.
It's also Berger, Your Honor.
Pardon?
Astry is my maiden name. Berger is actually my married name. I'm still married, sir. I just wanted the court to be aware.
Everything the state has on our information has her as Astry.
This is Miss Berger, or Miss Astry, was picked up on a warrant that was issued September 7th of 2017, alleging that she had failed to report as ordered to her probation officer. She had moved from a residence that was listed, or wasn't occupying the residence that she had listed with probation, that she had ceased cooperating with the ACC, and her whereabouts were unknown, and that she had fallen in arrears on certain of her financial obligations. All of those are the allegations contained in the petition that was filed in 2017. At this time,
Right.
the court is making the appointment of the Public Defender's Office to represent Ms. Berger. Mr. Cooper, how does she now plead?
Not true, Your Honor.
It is not true, is noted on the record. Court is setting this matter down for hearing when next the court's over here, which will be March 7th.
You're kidding me. can't I just plead guilty?
Any
Your
further?
Honor, I think I heard her say that she wanted to plead today.
Yes, can I please speak, Your Honor?
Yes, you may.
Okay. Your Honor, yes, I'm 100% responsible for, not reporting, and I will take my consequences. That was all me. For this last year, I have not reported, but I have been homeless. But just recently, I've been helping an elderly man for room and board. I have no phone, I have no car. I know I should have took it upon myself to walk from Lakeview all the way to Mountain Home to report, and that's my own fault, Your Honor, and I'm really, really sorry. But I take full responsibility on it. This is 100% my fault. But I've been out in Lakeview I've been out there for over a year getting clean, getting straight, and I have no new offenses, Your Honor. I haven't got arrested. I have no new charges. I'm in here doing 15 days just to make sure my misdemeanor fines are paid off. I'll be willing to do, Your Honor, I just wanted to ask, is there an Act 570 for people on probation? Or since I have no new charges, and I want to plead guilty. It's my fault. It's nobody else's fault that I didn't go and report. It's completely my fault.
At this time, you haven't had an opportunity to discuss this with your attorney, have you?
No, sir, but I know I'm going to get a sanction. I know it's been a really tough year for me, but I had to get off drugs, and the only way I knew I'd do it was go somewhere I didn't know people.
Your Honor, I have seen the recommendations on Ms. Berger, and I will tell her that I think that she needs to let me come down and visit with her. This involves more than a sanction by the proposal of the state today. And if she wants to be brought over knowing that the proposal is incarceration, then we can bring her over for that reason. But I don't think I don't think we're on the same page.
I don't think we are either.
Okay.
I did not know about these new other charges. Oh,
Well, ma'am, there are no other charges. The ones I read off to you, I've entered a plea if not true on you, and I've set the matter for hearing on March 7th. Between now and March 7th, you indicated that you're serving a period of time in jail to address some fines that you have outstanding. That period of time would sound like it will cover the time between now and March 7th.
Yep.
So you're going to be in jail anyway. I think you'd be well advised to meet with Mr. Cooper, discuss what kind of a arrangement he can work out for you and what the disposition is proposed, and then decide whether you want to plead or go to hearing on March 7th. So that's what I'm suggesting is appropriate today.
okay, Your Honor, I will take your suggestion.
All right. You may be excused at this time.
Thank you, Your Honor.